So there's a video making the rounds showing two police officers in the UK arresting someone who appears to be a senior citizen. The reason the video is going viral is because the crime appears to consist of the man posting something offensive on Facebook.
So I'm actually being arrested?
You're going to be arrested, okay?
Right.
Take you up to the police station.
Right.
You, okay, this is in relation to some comments that you've made on a Facebook page. Okay?
Oh, really? Oh, it's a Facebook crime, is it?
Okay.
Right.
So we need to ask you some questions about that.
At first I couldn't really believe this was happening, but then I decided to look into the law being referred to here by the officers. Now I don't know if the video is showing something that happened recently, or if this is an older video resurfacing or only getting shared now. But since we're looking into the law, and the law hasn't changed, that doesn't really matter. The law that the officers are referring to is Section 127 of the Communications Act of 2003. Section 127 falls under the offences relating to networks and services category, and it pertains to the improper use of a public electronic communications network. Electronic communications network has some complicated and convoluted definition, but I think it is fair to say that it can essentially refer to any type of social media. Let's look at the text of Section 127. 1. A person is guilty of an offence if he a. sends by means of a public electronic communications network a message or other matter that is grossly offensive or of an indecent, obscene, or menacing character, or b. causes any such message or matter to be sent. 2. A person is guilty of an offence if, for the purpose of causing annoyance, inconvenience, or needless anxiety to another, he a. sends by means of a public electronic communications network a message that he knows to be false, b. causes such a message to be sent, or c. persistently makes use of a public electronic communications network. 3. A person guilty of an offence under this section shall be liable, on summary conviction, to imprisonment for a term not exceeding 6 months, or to a fine not exceeding level 5 on the standard scale, or to both. 4. Subsections 1 and 2 do not apply to anything done in the course of providing a program service within the meaning of the Broadcasting Act of 1990. There are some additional subsections after this, but they are about jurisdiction and procedural stuff and not really interesting here. Now, there is quite a lot going on, so let's take it bit by bit. Firstly, we have subsection 1a, which appears to be the one that the man is getting arrested for. A person is guilty of an offence if he sends a message or other matter that is grossly offensive or of an indecent, obscene, or menacing character. This immediately raises the question, what is grossly offensive, indecent, obscene, or menacing, and indeed who makes such a determination? For example, are salacious images of scantily clad women on Instagram of an indecent or obscene character? Or on X, you can post actual nudity or pornography. Is that against UK law? At what point do jokes stop being jokes and start being grossly offensive? And what exactly is menacing? I'm not a legal scholar and I don't want to rule out that these terms are defined somewhere in UK legislation or case law, but I certainly have not been able to find those definitions in the code itself. If somebody out there knows something more concrete, I would be grateful if you could point me towards additional information. As I see this right now, this kind of language is highly open to interpretation and therefore open to selective application of the law. Unfortunately, the phrase, "show me the man and I'll show you the crime," comes to mind. If you want to punish someone, you can find a reason to do so. If you don't want to punish someone, you just don't. But let's continue with subsection 2. A person is guilty of an offence if, for the purpose of causing annoyance, inconvenience, or needless anxiety to another, he a. sends a message that he knows to be false, b. causes such a message to be sent, or c. persistently makes use of a public electronic communications network. Now, there is actually a footnote here regarding parts A and B, and it states that these have been repealed by the Online Safety Act of 2023. Technically, it is true that they have been repealed in this Communications Act, but they are not gone. Replaced or superseded is probably more fitting in colloquial terms. Essentially, it is still an offense to knowingly spread false information, but the definition of the offense has been moved to the Online Safety Act of 2023. That one has an entire section devoted to false communication offenses. In the Communications Act, both 2A and 2B refer to knowingly spreading false information, which is an interesting topic by itself, but not what I want to look at here. I am more interested in what we're left with when we look at Part C only. A person is guilty of an offense if, for the purpose of causing annoyance, inconvenience, or needless anxiety to another, he persistently makes use of a public electronic communications network. Yes, you heard that right. It appears to be illegal to be willfully annoying on the internet. I don't know about you, but to me this sounds like half of the users on X are breaking UK law on a daily basis. It is also illegal to willfully cause inconvenience or needless anxiety to somebody else. Of course, whether somebody experiences anxiety is entirely subjective, and I'm sure the person experiencing that anxiety will also consider it to be entirely needless. Let's consider a situation in which a politician is terrible at their job. Should not be a stretch to imagine. And this politician is getting a lot of flack on social media. People are voicing their outrage. They are demanding the politician resign. Could this be causing the politician some needless anxiety and inconvenience? Absolutely it could. And would this be a willful act from those who are voicing their frustrations? Of course it would. And people should be allowed to exert social pressure on incompetent politicians. Now, violence or threats of violence are of course absolutely taboo. But nowhere in this piece of legislation is it mentioning violence or incitement or spreading hatred. All of this is merely about being grossly offensive, indecent, obscene, or menacing, and causing annoyance, inconvenience, or needless anxiety. This is insane. And initially I thought this was a modern phenomenon. The Communications Act has been amended a few times, but as it turns out, the exact wording of subsections 1 through 4 has been in this piece of legislation from the very beginning in 2003. That was over 20 years ago. Let's cover the next two subsections. According to subsection 3, a person guilty of an offense under this section shall be liable, on summary conviction, to imprisonment for a term not exceeding 6 months, or to a fine not exceeding level 5 on the standard scale, or to both. Yes, you can actually go to prison for this. And according to the Sentencing Act of 2020, a level 5 fine currently corresponds to £5,000. Subsection 4 is interesting as well because subsections 1 and 2 do not apply to anything done in the course of providing a program service within the meaning of the Broadcasting Act of 1990. Unfortunately, the definition of program service seems pretty convoluted, but my understanding is that this refers to proper broadcasters in scare quotes. So if you have your own YouTube channel with a regular show or a podcast, you would not be covered under that definition, and subsections 1 and 2 would apply to your content just as they do to Facebook posts. Now, it would of course be tempting to assume that the legacy media are allowed to do whatever they want, but this does not seem to be the case. Instead, they have to follow their own more elaborate set of rules. For example, in the Broadcasting Act of 1990, there are stipulations regarding obscenity, racially inflammatory material, and defamation. I have not checked these in detail, but there appear to be both restrictions as well as carve-outs. And on the face of it, I have not found anything that relates to things being grossly offensive or menacing, or causing annoyance, inconvenience, or needless anxiety. There is a clause that stood out to me though, and that is Section 22 from the Public Order Act of 1986. It stipulates that 1. If a program involving threatening, abusive, or insulting visual images or sounds is included in a program service, each of the persons mentioned in subsection 2 is guilty of an offense if a. he intends thereby to stir up racial hatred, or b. having regard to all the circumstances, racial hatred is likely to be stirred up thereby. 2. The persons are a. the person providing the program service, b. any person by whom the program is produced or directed, and c. any person by whom offending words or behavior are used. Leaving the intent to stir up racial hatred aside, it is entirely sufficient for an offense that racial hatred is likely to be stirred up by the content in question. And it does make me wonder, what does this mean for critical reporting on sensitive and racially charged topics? Or for having controversial, outspoken guests on a discussion panel? Or for interviewing someone on the street who is frustrated and doesn't mince words? As I understand it, the only defenses under this section are if the person involved didn't know that the material would be included or had no control over it, or if the person didn't know the material was likely to stir up racial hatred. But if you are creating a piece that critically examines a racially charged topic, for example migration, and the piece contains material that is sensitive and could spark outrage, surely as the producer of that piece you are aware. Again, I'm not a legal scholar, and I don't know if there are other parts of the law that soften these stipulations here, but it seems to me that if you're a broadcaster, director, or producer, you'll think twice about touching anything that is racially sensitive, because doing so would open yourself up to legal trouble. Anyway, let's get back to our Facebook crime. We don't know exactly what it was that the man wrote on Facebook, but just in case you think that he must have been inciting violence or spreading hatred, that would seem very unlikely to me. None of that is part of Section 127 of the Communications Act. Again, this is about something being offensive, indecent, obscene, or menacing, or causing annoyance, inconvenience, or needless anxiety. What the officer says also seems extremely banal, but she won't provide further details unless he comes back to the station with them, which I find completely reprehensible, by the way. You know, we're arresting you because you said something bad, but we're not going to tell you what it was until we have you in custody.
Some what information? But I'm going to be arrested for posting on Facebook.
Made some comments that are offensive, obscene, and people have made a complaint about that, and it's sounds like they've come from
can you tell me what this comment was?
Okay, well we'll do that when we interview.
All right. And so, what am I going to be locked up for the night, or?
Hopefully not. Hopefully not.
Right. Do I need to take my medications with me?
Yes, we will look at taking all of those.
So not only do they arrest him based on the suspicion that he has broken this crazy law, but they also tell him to stop filming or he'll be locked up for the night. This is absolutely crazy. Anyway, I am at a loss for further words, so I will leave things here.